Okay, hello everybody. Hello. Welcome in. Yes, this is hot off my printer, everybody. We have the U.S. Court of Appeals decision. Yes. Hello. I have not even read it yet, everybody. I wanted to come on as soon as I could. As soon as I could. Good morning. Yes, good morning. Good morning. Hello, everybody. All right, everyone. So we have the U.S. Court of Appeals for the District of Columbia Circuit's opinion. All right. So I'm not. Hello. I have not. Yes, the printer is smoking. I have not read it yet, everybody. So we can read it together here. I've not even annotated it at this point. So at this point, I'm just very excited that it finally came out. Oh, thank you for the gifts. Appreciate it. So I have not annotated it, everybody, but we can still go ahead and read through it. Yes, indeed. So, oh, yep, we've got a lot. Just saw it a minute ago. Yes, indeed. So, as everybody knows, we've been waiting on this. So, we finally have our decision here out of the U.S. Court of Appeals for the District of Columbia. We've got the United States here versus Mr. Trump. This was an appeal. So, this was the D.C. case regarding January 6th. And this was the case that has gone to the Court of Appeals. The U.S. Supreme Court rejected it and said, we'll let the Court of Appeals decide. And so we do have the decision today. So, everyone, I am going to go ahead and just dive right in. It's 57 pages. I'm not going to be able to read the full 57, I'll tell you that right now, but we'll read a good chunk of it to get going here. So yes, indeed. It is fascinating. So we'll go ahead and get started, everybody. Again, I've not annotated this yet, but we'll go ahead and read it nevertheless. So we have Henderson, Childs, and Pan as the circuit judges who decided this opinion here. So let's get started. The opinion of the court is filed per curiam. That means we don't know who wrote it. It's just from the bench. So we've got Donald J. Trump was elected the 45th President of the United States on November 8th of 2016. He was sworn into office at noon on January 20th of 2017, served until his term expired at noon on January 20th of 2021. At the moment, President Trump became former President Trump and his successor Joseph R. Biden became president and began his 4-year term. U.S. Constitution, Article 2, Section 1. Although this sequence is set by the Constitution, Amendment 20, it did not proceed peacefully. Indeed, from Election Day 2020 forward, the government alleges that President Trump denied that he had lost his bid for a second term and challenged the election results through litigation, pressure on state and federal officers, the organization of an alternate slate of electors, and other means. His alleged interference in the constitutionally prescribed sequence culminated with a Washington, D.C. rally held on January 6th of 2021, the day set by the Electoral Count Act, for Congress to meet in joint session to certify the election results. The rally headlined by President Trump resulted in a march of thousands to the Capitol and the violent breach of the Capitol building. The breach delayed the congressional proceedings for several hours, and it was not until the early morning of January 7th that the 2020 presidential election results were certified, naming Joseph R. Biden as the soon-to-be 46th president. Since then, hundreds of people who breached the Capitol on January 6th of 2021 have been prosecuted and imprisoned. And on August 1st of 2023, in Washington, D.C., former President Trump was charged in a 4-count indictment as a result of his actions challenging the election results and interfering with the sequence set forth in the Constitution for the transfer of power from one president to the next. Former President Trump moved to dismiss the indictment, and the district court denied his motion. Today, we affirm the denial. All right, so we have affirmed the lower court. Judge Chutkan has been affirmed, everybody. Yay! For the purpose of this criminal case, former President Trump has become Citizen Trump with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. So let's go to page 4. So here's the background. Number 1, former President Trump did not concede the 2020 election, and in the ensuing months, he and his supporters made numerous attempts to challenge the results. Many of their attempts were allegedly criminal. And then footnote 1 here, former President Trump's campaign and his supporters also unsuccessfully challenged the election results in several state and federal courts. A District of Columbia federal grand jury indicted former President Trump on 4 criminal counts arising from the steps he allegedly took to change the outcome of the election. 1, conspiracy to defraud the United States by overturning the election results in violation of 18 U.S.C. Section 371. 2, conspiracy to obstruct an official proceeding, the Congress's certification of the electoral vote in violation of 18 U.S.C. 1512K. And 3, obstruction of an attempt to obstruct the certification of the electoral vote in violation of 18 U.S. Code Section 1512C2. And 4, conspiracy against the rights of one or more persons to vote and to have their votes counted in violation of 18 U.S. Code Section 241. At this stage of the prosecution, we assume that the allegations set forth in the indictment are true. And then we're citing case law here. We emphasize that whether the indictment's allegations are supported by evidence sufficient to sustain convictions must be determined at a later stage of the prosecution. The indictment alleges that former President Trump understood he had lost the election and that the election results were legitimate, but that he nevertheless was determined to remain in power. He then conspired with others to cast doubt on the election's outcome and contrived to have himself declared the winner. Wow, that's pretty powerful coming from a court of appeals to state that. The indictment charges that he and his co-conspirators allegedly advanced their goal through 5 primary means. First, they used knowingly false claims of election fraud to attempt to persuade state legislators and election officials to change each state's electoral votes in former President Trump's favor. For example, he and his allies falsely declared that more than 10,000 dead voters had voted in Georgia, that there had been 205,000 more votes than voters in Pennsylvania, that more than 30,000 non-citizens had voted in Arizona, and that voting machines had switched votes from Trump to Biden. Second, then President Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states, attempting to mimic the procedures that the legitimate electors were supposed to follow. They then caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceeding on January 6th. Third, then President Trump and his co-conspirators pressed officials at the Department of Justice to conduct sham election crime investigations and send a letter to targeted states that falsely claimed the Justice Department had identified significant concerns that may have impacted the election outcome. Fourth, then President Trump and his co-conspirators attempted to convince then Vice President Mike Pence to use his ceremonial role in the January 6th certification proceedings to fraudulently alter the election results. When the Vice President rebuffed them, he stirred his base of supporters to increase pressure on the Vice President. Ultimately, on the morning of, I got it flipped to page 6. January 6th of 2021, he held a rally in Washington, D.C., where he repeated knowingly false claims of election fraud to gathered supporters and directed them to the Capitol to obstruct the certification proceedings and exert pressure on the vice president to take the fraudulent actions he had previously refused. Fifth and finally, from January 6th rally, thousands of his supporters, including individuals who had traveled to Washington and to the Capitol at his direction, swarmed the United States Capitol, causing violence and chaos that required the Congress to temporarily halt the election certification proceeding. At that point, he and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification. Then President Trump's efforts to overturn the election results were unsuccessful, and the Congress certified the Electoral College vote in favor of President-elect Biden. On January 11th of 2021, 9 days after President-elect Biden's inauguration, the House of Representatives adopted an impeachment resolution charging then President Trump with incitement of insurrection. The single article of impeachment alleged that he had violated his constitutional oath faithfully to execute the office of President of the United States and his constitutional duty to take care that the laws be faithfully executed by inciting violence against the government of the United States. The impeachment resolution asserted that President Trump repeatedly issued false statements, asserting that the presidential election results were the product of widespread fraud and should not be accepted by the American people or certified by state or federal officials. That his statements on the morning of January 6th encouraged and foreseeably resulted in lawless action at the Capitol, and that he attempted to subvert and obstruct the certification of the results of the 2020 presidential election by other means, including by threatening a Georgia state official into manipulating the results. Importantly, by the time the United States Senate conducted a trial on the article of impeachment, he had become former President Trump. At the close of the trial on February 13th of 2021, 57 senators voted to convict him and 43 voted to acquit him. Because 2/3 of the Senate did not vote for conviction, he was acquitted on the article of impeachment. On November 18th of 2022, the U.S. Attorney General appointed John L. Smith as special counsel to investigate efforts to interfere with the lawful transition of power following the 2020 presidential election or certification of the Electoral College vote. A Washington, D.C. grand jury returned an instant 4-count indictment against former President Trump on August 1st of 2023. And on August 28th of 2023, the district court set a trial date for March 4th of 2024. Former President Trump filed 4 motions to dismiss the indictment, relying on 1, presidential immunity, 2, constitutional provisions, including the impeachment judgment clause, and principles stemming from the double jeopardy clause, 3, statutory grounds, and 4, allegations of selective and vindictive prosecution. On December 1st of 2023, the district court issued a written opinion denying the 2 motions that are based on presidential immunity and the 2 constitutional provisions. In relevant part, the district court rejected Trump's claim to executive immunity from criminal prosecution, holding that, quote, former presidents enjoy no special conditions on their federal criminal liability. Citing that case here, it concluded that the Constitution's text, structure, and history do not support the existence of such immunity, and that it would betray the public interest to grant a former president a categorical exemption from criminal liability for allegedly attempting to usurp the reins of government. It also held that neither traditional double jeopardy principles nor the impeachment judgment clause provide that a prosecution following impeachment acquittal violates double jeopardy. Former President Trump filed an interlocutory appeal of the district court's presidential immunity and double jeopardy holdings. On December 13th of 2023, we granted the government's motion to expedite the appeal, and oral argument was held on January 9th of 2024. Number 2, jurisdiction. So this is important, everybody, that we go through jurisdiction, because there were questions on whether or not the interlocutory appeal was even appropriate. So we will go through that. Although both parties agree that the court has jurisdiction over former President Trump's appeal, amicus curiae American Oversight raises a threshold question about our collateral order jurisdiction. In every case, we must assure ourselves of our jurisdiction. Under 28 U.S.C. 1291, which grants us jurisdiction over final decisions of the district courts, we ordinarily do not have jurisdiction to hear a defendant's appeal in a criminal case prior to conviction, and sentencing. The collateral order doctrine, however, treats as final and thus allows us to exercise appellate jurisdiction over a small class of interlocutory decisions that conclusively determine the disputed question, resolve an important issue completely separate from the merits of the action, and are effectively unreviewable on appeal from a final judgment. Sticky notes. Yes, let me get one here. Hold on. All right, everybody, we're pausing for sticky notes break. So this is U.S. v. Trump, and this is the Court of Appeals decision on presidential immunity. Okay. Immunity. There we go. Oh, of course, Deborah, of course. Sometimes I forget these things. I get too excited about reading it and I forget. I'm sure probably every third person is asking what this is. So this is the case number here. So I'm going to put the number here, everybody, and then you can pull this up online yourself as well. So let me just zoom back out. Imposter accounts. Okay, well, it's possible. As long as they're not trying to make any money, I don't particularly go after them, but make sure to message me with the name of the account. How is this? Can everybody see now? Can everybody see? Oh, absolutely, Deborah. How's it looking? Is this looking okay? I don't want to get too much of the comments out. They're posting your content. Okay, good to know. Okay, it's good. Yes, we can see. All right, good enough, everybody. Good enough for now. All right, good to go. Here we go. Let me jump back in. All right, excellent. Document review is so much better. Oh, good. All right, thank you, Deborah, for telling me. I do appreciate that. All right, so here we were. We were asking whether or not they had jurisdiction. The collateral order doctrine, however, treats as final and thus allows us to exercise appellate jurisdiction over a small class of interlocutory decisions that conclusively determine the disputed question, resolve an important issue completely separate from the merits of the action, and are effectively unreviewable on appeal from final judgment. And reciting case law. The district court's denial of former President Trump's immunity defense unquestionably satisfies the first two requirements. Thus, we focus our analysis on the third, whether the denial of immunity is effectively unreviewable on appeal from a final judgment. District court orders rejecting claims of civil immunity are quintessential examples of collateral orders, citing Nixon v. Fitzgerald, the Blasingame case. But in Midland, the Supreme Court counseled that collateral order doctrine is interpreted with the utmost strictness in criminal cases. In the Midland case, it emphasized that criminal collateral orders are based on a right not to be tried and must rest upon an explicit statutory or constitutional guarantee that the trial will not occur. Singling out double jeopardy clause and the speech or debate clause. Former President Trump does not raise a straightforward claim under the double jeopardy clause, but instead relies on the impeachment judgment clause and what he calls double jeopardy principles. The double jeopardy principle he relies on is a negative implication drawn from the impeachment judgment clause. Thus, he does not invoke our jurisdiction based on explicit grant of immunity found in the double jeopardy clause. Nevertheless, we can exercise jurisdiction for two reasons. First, Midland asphalt is distinguishable and does not require immunity to derive from an explicit textual source. And second, the theories of immunity former President Trump asserts are sufficient to satisfy the Midland asphalt under circuit precedent. So they do have jurisdiction, everybody. Distinguishing Midland Asphalt. I am going to go ahead and skip through the jurisdiction argument, everyone. They have determined they have jurisdiction. So the next piece will be them going into the analysis of the Midland Asphalt case here. So if you are interested in that, I encourage you to pull the case and read it. But that is subsection A here. We're going again through why they have jurisdiction to hear the case. Here we go as well again, and then they're setting out what circuit precedent is regarding their jurisdiction. I will go through just the first paragraph here and just kind of skip through again. Our circuit precedent has taken a broad view of Midland Asphalt, consistently holding that denial of a right not to stand trial is immediately appealable if the right is similar or analogous to one provided in the Constitution. Both of the former President Trump's asserted sources of immunity, separation of powers, and double jeopardy principles fit within the window of appealability. So again, they are saying the words I've never heard before. Oh, you're welcome, Tina. So again, they are going through and citing different cases, supporting the fact that they have the authority to make this decision. This is not one of the biggest issues in the case, so I will skip through that until I get to page 18 where they start talking about executive immunity. So I highly recommend going back and reading through that if you've got questions about jurisdiction. So next, let's get into executive immunity. All right, for all immunity doctrines, the burden is on the official claiming immunity to demonstrate his entitlement. Former President Trump claims absolute immunity from criminal prosecution for all criminal acts undertaken as president, a category he contends that includes all of the conduct alleged in the indictment. The question of whether a former president enjoys absolute immunity from federal criminal liabilities is one of first impression. We're citing the Blessing Game case here, noting the unresolved question of whether or when a president might be immune from criminal prosecution. I think it's important to note the Blessing Game case is a civil lawsuit against Mr. Trump for people who were harmed on January 6th. The Supreme Court has consistently held that even a sitting president is not immune from responding to criminal subpoenas issued by state and federal prosecutors, citing Trump v. Vance, the Nixon case, U.S. v. Burr. In the civil context, the Supreme Court has explained that a former president is absolutely immune from civil liability for his official acts, defined to include any conduct falling within the outer perimeter of his official responsibility, citing the Fitzgerald case. Both sitting and former presidents remain civilly liable for private conduct, citing Clinton v. Jones and Blessing Game. When considering the issue of presidential immunity, the Supreme Court has been careful to note that its holdings on civil liability do not carry over to criminal prosecutions. See the Fitzgerald case, explaining that lesser public interest in actions for civil damages than, for example, in criminal prosecutions. Also citing Clinton v. Jones, noting special considerations at issue in criminal cases. Former President Trump's claimed immunity would have us extend the framework of presidential civil immunity to criminal cases and decide for the first time that a former president is categorically immune from federal criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility. He advances 3 grounds for establishing this expansive immunity for former presidents. Number 1, Article 3 courts lack the power to review the president's official acts under the separation of powers doctrine. 2, functional policy considerations rooted in the separation of powers require immunity to avoid intruding on executive branch functions. And 3, the impeachment judgment clause does not permit the criminal prosecution of a former president in the absence of Congress impeaching and convicting him. And we'll flip the page here. Hopefully flip the page. Our analysis is guided by the Constitution, federal statutes, and history, as well as concerns of public policy, citing the Fitzgerald case. Relying on these sources, we reject all three potential bases for immunity, both as categorical defense to federal criminal prosecution of a former president and as applied to this case in particular. So that's a significant holding, everybody, here. They're rejecting all three of the defenses that were set out. Each one of them is being rejected. All right, so A, separation of powers doctrine. The President of the United States occupies a unique position in the constitutional scheme. Under the separation of powers established in the Constitution, the President is vested with executive power, which entails the duty to take care that the laws be faithfully executed, and supervisory and policy responsibilities of utmost discretion and sensitivity. The President's constitutional role exists alongside the Congress's duty to make the laws and the judiciary's duty to say what the law is. It is settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States, citing Fitzgerald and the Nixon v. U.S. case. Sustain an absolute unqualified presidential privilege or immunity from judicial process under all circumstances. Nevertheless, former President Trump argues that the constitutional structure of separated powers means that neither a federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts, which are vested in the presidency alone, citing the appellant's brief. Yes, I will repost as best as I can, everybody. He relies on Marbury's oft-quoted statement that a president's official's acts can never be examinable by courts, quoting Marbury here. Former President Trump misreads Marbury and its progeny. Properly understood, the separation of powers doctrine may immunize lawful discretionary acts, but does not bar the federal criminal prosecution of a former president for every official act. Marbury distinguished between two kinds of official acts, discretionary and ministerial. As to the first category, Chief Justice Marshall recognized that the president is invested with certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and his own conscience. When the president or his appointed officers exercise discretionary authority, the subjects... Sorry, everyone. One moment, please. When the president or his appointed officers exercise discretionary authority, the subjects are political, and the decisions of the executive is conclusive. Their discretionary acts, therefore, can never be examinable by the courts. But Chief Justice Marshall continued, when the legislature proceeds to impose on that officer other duties, when he is directed peremptorily to perform certain acts, when the rights of individuals are dependent on the performance of those acts, he is so far the officer of the law, is amenable to the laws for his conduct, and cannot at his discretion sport away the vested rights of others, citing Marbury versus Madison. Under these circumstances, an executive officer acts as a ministerial officer, compellable to do his duty, and if he refuses, is liable to indictment. Quoting, "It is not consistent with the policy of our political institutions or the manners of the citizens of the United States that any ministerial officer having public duties to perform should be above the compulsion of the law in the exercise of those duties." End of quote. Based on these principles, Chief Justice Marshall concluded that although discretionary acts are only politically examinable, the judiciary has power to hear cases where a specific duty is assigned by law. Marbury thus makes clear that Article III courts may review certain kinds of official acts, including those that are legal in nature. The cases following Marbury confirm that we may review the president's actions when he's bound by the law, including by federal criminal statutes. In Little v. Barem, the Supreme Court concluded that the president's order to a subordinate officer to seize American ships traveling to or from French ports violated the Non-Intercourse Act precisely because the Congress had acted to constrain the executive's discretion. Chief Justice Marshall observed that the president may have had the discretionary authority to order the seizure absent legislation, but had no discretion to violate the act. Similarly, in Kendall v. U.S., the Supreme Court reviewed the official acts of the Postmaster General, the president's subordinate officer, who derived his authority from the executive branch because the civil case involved in the violation of a statutory requirement. To find a statutory violation unreviewable, the court held would be clothing the president with a power entirely to control the legislation of Congress and paralyze the administration of justice. Then, the Mississippi v. Johnson, the Supreme Court considered whether the state of Mississippi could sue President Andrew Johnson to enjoin him from enforcing the Reconstruction Acts, which the state alleged were unconstitutional. The court concluded that it lacked jurisdiction to issue an injunction, relying on Marbury, Kendall, and the distinction between the mere ministerial duties, in which nothing was left to discretion, and purely executive and political duties involving the president's discretion. Citing Martin v. Mott, no judicial power to review presidential exercising his discretionary power conferred by statute. In holding that it could not enjoin the president from using his discretion, the court nevertheless affirmed the role of the judiciary in checking the other two branches of government. The Congress is the legislative department of the government. The president is the executive department. Neither can be restrained in its action by the judicial department, though the acts of both, when performed, are in proper cases subject to its cognizance. So I think that's a very important piece here. The Supreme Court exercised its cognizance over presidential action in dramatic effect in 1952 when it had held that President Harry Truman's executive order seizing control of most of the country's steel mills exceeded his constitutional and statutory authority and was therefore invalid, citing the Youngstown Sheet and Tube v. Sawyer case. The Congress had not legislated to authorize President Truman's seizure and in fact had refused to adopt the seizure method of settling labor disputes. President Truman could lawfully act only to execute the Congress's laws or to carry out his constitutional duties as the executive, and he lacked authority from either source to seize the steel mills. As Justice Jackson explained, the court's holding in validating the executive order was proper because when the president takes measures incompatible with express or implied wills of Congress, his power is at its lowest ebb. Based on Youngstown and Marbury, the Supreme Court in Clinton easily concluded when the president takes official action, the court has the authority to determine whether he acted within the law, citing the Clinton v. Jones case. Objection may be made when Marbury and its progeny exercised jurisdiction only over subordinate officers, not the president himself. The writ in Marbury was brought against the Secretary of State, in Little against the commander of a ship of war, in Kendall against the Postmaster General, in Youngstown against the Secretary of Commerce. But as the Supreme Court has unequivocally explained, no man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes upon the exercise of the authority which it gives. Citing U.S. v. Lee, that principle applies of course to a president, citing Vance. Further, the Supreme Court has repeatedly affirmed the judiciary's power to direct appropriate process to the president himself. Citing Clinton v. Jones, the president does not enjoy absolute immunity from criminal subpoenas issued by state or federal prosecutors and may be compelled by the courts to respond. Citing the Burr case, Nixon, and Vance. We have 200 years of precedent establishing that presidents and their official communications are subject to judicial process, even when the president is under investigation. Citing Vance and Clinton, recounting history of sitting presidents complying with court orders to provide testimony and other evidence. The separation of powers doctrine, as expounded in Marbury and his progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of Congress's laws. Although certain discretionary actions may be insulated from judicial review, the structure of the Constitution mandates that the president is amenable to the laws for his conduct and cannot at his discretion violate them. Citing Marbury versus Madison. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not properly within the scope of his lawful discretion. Accordingly, Marbury and its progeny provide him no structural immunity from the charges in the indictment. Our conclusion that the separation of powers doctrine does not immunize former presidents from federal criminal liability is reinforced by the analogous immunity doctrines for legislators and judges. Legislators and judges are absolutely immune from civil suits for any official conduct, and legislators have an explicit constitutional immunity from criminal prosecution arising from the speech or debate clause. Nevertheless, legislators and judges can be criminally prosecuted under generally applicable laws for their official acts consistent with the separation of powers doctrine. Legislators have explicit constitutional immunity from criminal or civil liability for what they do or say in the legislature proceeding under the speech and debate clause, citing the Tenney case in Article 1, Section 6, Clause 1. But outside of constitutionally protected legislative conduct, members of the Congress perform a wide range of acts in their official capacity that are not legislative in nature, and so can subject them to criminal liability. Citing the Gravel case, speech and debate clause does not privilege either senator or aide to violate an otherwise valid criminal law in preparing for and implementing legislative acts. In U.S. v. Johnson, a congressman was criminally charged with conspiring to pressure the Department of Justice to dismiss pending indictments of a loan company and its officers on mail fraud charges. The Supreme Court held that the prosecution could not include evidence related to the speech made by Johnson on the House floor because of his constitutional immunity. But the court made clear Johnson could be retried on the same count, wholly purged of the elements offensive to the speech and debate clause. Although the unprotected conduct constituted an official act under Fitzgerald, communicating with the executive branch, it was constrained by and subject to criminal statutes of general application. Judges are similarly liable to the criminal laws for their official acts. A notable example is Ex parte Commonwealth of Virginia, in which the Supreme Court applied Marbury's discretionary ministerial distinction to affirm the criminal indictment of a judge based on an official act. In 1879, a county judge was indicted in federal court for violating a federal statute that prohibited discriminating on the basis of race in jury selection. The Supreme Court began by observing the principle that officers are bound to follow the law. We do not perceive how holding an office under a state and claiming to act for the state can relieve the holder from obligation to obey the Constitution of the United States or take away the power of Congress to punish his disobedience. The court then addressed the judge's argument that the court lacked the authority to punish a state judge for his official acts. Its response was twofold. First, the court described juror selection as merely a ministerial act, as much so as the act of a sheriff holding an execution in determining upon which piece of property he will make a levy, or act of a roadmaster in selecting laborers to work on the roads. The courts then explained that even if a juror's selection is considered a judicial act, the judge had a legal duty to obey the criminal laws. Tea break, everybody. But if the selection of jurors could be considered in any case a judicial act, can an act charged against the petitioner be considered such when he acted outside of his authority and in direct violation of the spirit of the state statute? That statute gave him no authority when selecting jurors from whom a panel might be drawn for a circuit court to exclude all colored men merely because they were colored. Such an exclusion was not left within the limits of his discretion. It is idle, therefore, to say that the act of Congress is unconstitutional because it inflicts penalties upon state judges for their judicial action. It does no such thing. More recent case law on the judicial immunity doctrine affirms that judges are not immune from criminal liability for their official acts. O'Shea v. Littleton confirmed the holding in Ex parte Virginia in dismissing a civil rights action for equitable relief brought against a county magistrate and associate judge of his county circuit, 1974 case. The Supreme Court concluded that the requested injunction was not the only available remedy because both judges remained answerable to the federal criminal laws. We have never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivation of constitutional rights. On the contrary, the judicially fashioned doctrine of official immunity does not reach so far as to immunize criminal conduct proscribed by an act of Congress. Similarly, in Dennis v. Sparks, the court affirmed judicial immunity from civil money damages in the context of bribery allegations, but explained that judges are subject to criminal prosecutions as are other citizens. Crucially, the judge in Dennis retained civil immunity because the challenged conduct, allegedly issuing an injunction corruptly after accepting bribes as part of a conspiracy, was an official judicial act within his statutory jurisdiction, broadly construed. The scope of civil judicial immunity thus aligns with civil presidential immunity under Fitzgerald, but a judge has no criminal immunity for the same official act. Citing the Pachman case, even judges cloaked with absolute civil immunity for centuries could be punished criminally for willful deprivation of constitutional rights. Citing the Gillock case, the cases in this court which have recognized an immunity from civil suit for state officials have presumed the existence of federal criminal liability as a restraining factor on the conduct of state officials. And then we have footnote 7 here. In his brief, former President Trump contends otherwise, primarily relying on 2 words in a single line of dictum from Spalding v. Villas to urge that judges are immune from criminal prosecution for their official acts. Spalding was a civil case in which the Supreme Court quoted an opinion of the Supreme Court of New York, quote, "The doctrine which holds a judge exempt from a civil suit or indictment for an act done or omitted to be done by him sitting as a judge has a deep root in the common law." Quoting an 1896 case and an 1810 case, the Supreme Court did not analyze the scope of the judicial criminal immunity itself, and the quoted New York language is flatly incompatible with the Supreme Court case law addressed supra. We do not consider Spalding's dictum binding on the question of judicial criminal liability. When considering the criminal prosecution of judges in other circuits have repeatedly rejected judicial criminal immunity for official acts, largely in the context of bribery prosecutions. And then they're citing a bunch of case law here. Former President Trump argues that bribery allegations were not considered judicial acts at common law. but his sources do not support his conclusion. He is correct that Blackstone and other early common law sources expressly contemplated the criminal prosecution of judges on bribery charges, but this shows only the judicial immunity did not stretch to shield judges from generally applicable criminal law, not that bribery was ever considered a non-official act. And, as explained supra, the Supreme Court emphasized the official nature of the bribery allegations in Dennis while reinforcing the judge's criminal liability. We therefore conclude that Article 3 courts may hear the charges alleged in the indictment under the separation of powers doctrine as explained in Marbury and its progeny, and applied in the analogous context of legislative and judicial immunity. The indictment charges that former President Trump violated criminal laws of general applicability. Acting against laws enacted by Congress, he exercised power that was at its lowest ebb, citing Youngstown. Former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he is answerable in court for his conduct. So that's another huge piece as well. Let's take a look here. So B, we have functional policy considerations. I do want to make sure to go into all of the immunity discussions that we have here. Even though it is proper under Marbury and its progeny for an Article 3 court to hear criminal charges brought against a former president, we necessarily must weigh concerns of public policy, especially as illuminated by our history and structure of our government, including our constitutional heritage and structure. So I think this will be an important piece for the Supreme Court arguments. Citing Fitzgerald, our historical analysis merges with public policy analysis because the precedent did not exist through most of the development of common law. Citing Clinton, courts apply a functional approach in determining the scope of official immunity. This inquiry involves policies and principles that may be considered implicit in the nature of the president's office in a system structured to achieve effective government under a constitutionally mandated separation of powers. Citing Fitzgerald, our analysis entails balancing the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. And then citing Fitzgerald again, we note at the outset of our analysis is that our analysis is specific to the case before us, in which a former president has been indicted on federal criminal charges arising from his alleged conspiracy to overturn federal election results and unlawfully overstay his presidential term. Footnote 8 here. We do not address policy considerations implicated in the prosecution of a sitting president or in a state prosecution of a president sitting or formal. So that distinction is important. We consider the policy concerns at issue in this case in two respects. First, we assess possible intrusions on the authority and functions of the executive branch and the countervailing interests to be served as those concerns apply to former President Trump's claim that former presidents are categorically immune from federal prosecution. We conclude that the interest in criminal accountability held by both the public and the executive branch outweighs the potential risks of chilling presidential action and permitting vexatious litigation. I think that's a very important piece as well. Here, don't want to miss that. Second, we examine the additional interests raised by the nature and charges of the indictment. The executive branch's interest in upholding presidential elections, investing power in a new president under the Constitution, and the voters' interest in democratically selecting their president. We find these interests compel the conclusion that former President Trump is not immune from prosecution under the indictment. That's another key piece as well. All right, everyone. So let's talk about categorical immunity defense. So this is the key analysis we've been waiting for. Here we go. Oop, let me take a drink of tea first. Categorical immunity defense. Former President Trump argues that criminal liability for former president risks chilling presidential action while in office and opening the floodgates to meritless and harassing prosecution. These risks do not overcome the public interest in fair and accurate judicial proceedings, which is at its height in the criminal setting, citing the Vance case, which Trump was one of the parties. Former President Trump first asserts that the prospect of potential post-presidency criminal liability would inhibit a sitting president's ability to act fearlessly and impartially, citing the especially sensitive duties of the president and the need for bold and unhesitating action, citing the appellant's brief. But the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive powers is too remote and shadowy to shape the course of justice, citing the Clark case. In Clark, the Supreme Court dismissed the threat of a chilling effect, holding that jurors could be subject to criminal prosecution for conduct during their jury service and explaining that a juror of integrity and reasonable firmness will not fear to speak his mind if the confidences of debate are barred to the ears of mere impertinence or malice. Rather, the court observed he will not expect to be shielded against the disclosure of his conduct in the event that there is evidence reflecting upon his honor. The court reinforced the point in U.S. v. Nixon, holding that it could not conclude that the presidential advisors will be moved to temper their candor or remarks by the infrequent occasions of disclosure because of the possibility that such conversations will be called for in the context of a criminal prosecution. So too here. Wow, that's very powerful. Yikes. We cannot presume that a president will be unduly cowed by the prospect of post-presidency criminal liability. Oh, dear. Yikes. More than a juror would be influenced by the prospect of post-deliberation criminal liability, or an executive aide would be quieted by the prospect of the disclosure of communications in a criminal prosecution. Moreover, past presidents have understood themselves to be subject to impeachment and criminal liability, at least under certain circumstances. So the possibility of chilling executive action is already in effect. Even former President Trump concedes that criminal prosecution of a former president is expressly authorized by the impeachment judgment clause after impeachment and conviction, and they're citing the oral argument transcripts. Yes, hold on. I will do a summary here when I finish. We presume that every president is aware of the impeachment judgment clause and knows that he's liable and subject to indictment, trial, judgment, and punishment according to the law, at least after impeachment and conviction. So what the court is saying here is one of Mr. Trump's arguments was if we don't give absolute immunity, presidents are going to be hesitant about doing their job properly. And what the court is saying, if a president is hesitant because they might be prosecuted criminally, that situation is so rare, and they should be hesitant and think about criminal repercussions anyway. So, this is a rare situation. It shouldn't happen. And if they're doing something that could be criminal, then, that's too bad. They shouldn't have said it in the first place. Additionally, recent historical evidence suggests that former presidents, including President Trump, have not believed themselves to be wholly immune from criminal liability for official acts during their presidency. President Gerald Ford issued a full pardon to former President Richard Nixon, which both former presidents evidently believed was necessary to avoid Nixon's post-resignation indictment. Before leaving office, President Clinton agreed to a 5-year suspension of his law license and a $25,000 fine in exchange for independent counsel Robert Ray's agreement not to file criminal charges against him. Well, that's interesting. I didn't know that. Did anyone else know that? 5-year law license suspension? Interesting. And during President Trump's 2021 impeachment proceeding for incitement of insurrection, his counsel argued that instead of post-presidency impeachment, the appropriate vehicle for investigation, prosecution, and punishment is Article 3 courts, as we have a judicial process and an investigative process to which no former office holder is immune, citing the congressional record, quoting Mr. Trump's attorney. Yikes. The text of the Constitution makes very clear that a former president is subject to criminal sanction after his presidency for any illegal acts he commits. Again, quoting President Trump's, quoting his attorney during the impeachment trial. In light of the express mention of indictment in the impeachment judgment clause and recent historical evidence of former presidents acting on the apparent understanding that they are subject to prosecution even in the absence of conviction by the Senate, the risk of criminal liability chilling presidential action appears to be low. Oh my goodness. Instead of inhibiting the president's lawful discretionary action, the prospect of federal criminal liability might serve as a structural benefit to deter possible abuses of power and criminal behavior. So again, the court's just backing this up and saying, if we were to give complete immunity, maybe we wouldn't have that check in place and presidents would do criminal behavior. Quote, where an official could be expected to know that certain conduct would violate statutory or constitutional rights, he should be made to hesitate. And we're citing the Harlow v. Fitzgerald case. As the district court observed, every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them. That's a good quote too. And we're citing a Trump case. Former President Trump next urges that a lack of criminal immunity will subject future presidents to politically motivated prosecutions as soon as they leave office. In the civil context, the Supreme Court found official acts presidential immunity necessary in part to avoid subjecting the president to trial on virtually every allegation that an action was unlawful or was taken for a forbidden purpose, citing Fitzgerald. In view of the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits of civil damages. But the decision to initiate a federal prosecution is committed to the prosecutorial discretion of the executive branch. Prosecutors have ethical obligations not to initiate unfounded prosecutions, and courts presume that they properly discharge their official duties. Citing Armstrong and further case law. There are additional safeguards in place to prevent baseless indictments, including the right to be charged by a grand jury upon a finding of probable cause. Grand juries are prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or an intent to harass. Additionally, former President Trump's predictive judgment of a torrent of politically motivated prosecutions finds little support in either history or the relatively narrow compass of the issues raised in this particular case. Citing the Clinton case. As former President Trump acknowledges that this is the first time since the founding that a former president has been federally indicted, weighing these factors, we conclude that the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions appears slight. That's so funny. Okay. On the other side of the scale, we must consider the constitutional weight of the interest to be served by allowing the prosecution of a former president to proceed. The public has a fundamental interest in the enforcement of criminal laws. Our historic commitment to the rule of law is nowhere more profoundly manifest then in our view that the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. Citing the Nixon case, as the Nixon court explained, wholly immunizing the president from criminal justice process would disturb the primary constitutional duty of the judicial branch to do justice in criminal prosecutions to such an extent that it would undermine the separation of powers by plainly conflicting with the function of the courts under Article 3. Oh my goodness gracious. Yikes. Take that, Supreme Court. There is also a profound Article 2 interest in the enforcement of federal criminal laws. The president has a constitutionally mandated duty to take care that the laws be faithfully executed. As part of this duty, the president is responsible for investigating and prosecuting criminal violations. Citing case law, lots and lots of case law here, and more case law. Beyond simply making explicit that a president must enforce the law, the Take Care Clause plays a central role in signifying the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. Oh my gosh, how profound is that? It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that laws be faithfully executed, were the sole officer capable of defying those laws with impunity. That's pretty powerful. The federal prosecution of a former president fits the case when the judicial action is needed to serve broad and public interests in order to vindicate the public interest in an ongoing criminal prosecution. The risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and too remote and shadowy to shape the course of justice. We therefore conclude that the functional policy consideration rooted in the structure of our government does not immunize former presidents from federal criminal prosecution. So that's important. So it's such a fundamental piece of how our system works that the laws have to be followed. All right, immunity from the indictment's charges is next. I am taking a look. I have not seen this document yet, everybody, so I'm taking a peek here just of what's coming up. Impeachment judgment clause. So they go through why the impeachment clause is not applicable here. I think that's important. Wow, the impeachment clause. Ooh, they're really going on about that. Double jeopardy principles is the next piece. So that's, oh dear, I see the Federalist Papers coming out. Yikes! The Blockberger test. So that's the double jeopardy test that we're talking about. Okay, and then we have the conclusion. So why don't I go through, I'll go through this next immunity analysis, everybody, and then I'll take a break at that point. Can you read the duty line from the second last paragraph? From the second to the last paragraph. Yes. All right. I think that's a great piece. So let's back up again here. Let's back up again here to this piece. Oh, thank you. All right. Beyond simply making explicit that a president must enforce the law, the Take Care Clause plays a central role in signifying the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. So that's very powerful, isn't it? It's saying, if we're not here to follow a leader, we follow laws. And that means our leaders have to also follow the laws. I think that's very powerful. And we don't follow a leader, we follow our laws. Yeah, very important, very important. I think that that's an amazing point that they're making. All right, everyone, I'll go through this next piece here before I take just a little break. So, which is an absolutely correct statement. I agree. I think that's a beautiful way of putting it. And again, that's a direct quote from the Youngstown case. All right, number 2, immunity from the indictment's charges. Yes, I do have a Tube of You channel, and because this is so highly requested, it takes a couple of hours for it to get through TikTok, and then I'll be able to upload it. In addition to the generally applicable concerns discussed supra, so previously, the allegations of the indictment implicate the Article 2 interests in vesting authority in a new president and the citizenry's interest in democratically selecting its president. The indictment alleges that the assertedly official actions at issue here were undertaken by former President Trump in furtherance of a conspiracy to unlawfully overstay his term as president and to displace his duly elected successor. That alleged conduct violated the constitutionally established design for determining the results of the presidential election, as well as the Electoral Count Act of 1887, neither of which establishes a role for the president in counting and certifying the Electoral College votes. So, there's no role that's been established for him. Where can you download this document? So what you'll need to do is if you pull up this case number right here, all right, it'll be the U.S. Supreme Court, or U.S. Court of Appeals. I'm sorry about that. That's what USCA means. U.S. Court of Appeals, case number 23-322-8, and you're looking for this number document, all right, and the filing date is today. Yep. All right, so, oh my goodness, thank you, Jennifer. All right, I'm going to take a drink of tea here, everybody. All right, so he has no role according to the Electoral Count Act or the Constitution. The alleged conduct also violated, also violated Article 2's mandate that a president hold his office during the term of 4 years. Ooh, that's a good point, too. We tried to go over the 4-year mark. The 20th Amendment reinforces the discrete nature of a presidential term, explicitly providing that the terms of the president and vice president shall end at noon on the 20th of January, and the terms of their successors shall then begin, quoting the 20th Amendment, upon the expiration of the time for which he is elected, a former president returns to the mass of people again, and the power of the executive branch vests in a newly elected president, citing the Burr case, along with Article 2, Section 1, Clause 1. The executive power shall be vested in a president of the United States. Emphasis added. Emphasis added to the A. Just the one president, everybody. The president, of course, also has a duty under the Take Care Clause to faithfully enforce the laws. This duty encompasses following the legal procedures for determining election results and ensuring that executive power vests in the new president at the constitutionally appointed time. To the extent former President Trump maintains that the post-2020 election litigation that his campaign and supporters unsuccessfully pursued implemented his Take Care Clause duty, he is in error. Oh my goodness. Former President Trump's alleged conduct conflicts with his constitutional mandate to enforce the laws governing the process of electing the new president. The public has a strong interest in the foundational principles of our government, that the will of the people, as expressed in the Electoral College vote, determines who will serve as president. Citing the 12th Amendment, the electors shall meet in their respective states and vote by ballot for president and vice president. The person having the greatest number of votes for president shall be the president. Citing case law, Early in our history, states decided to tie electors to the presidential choices of citizens. The Supreme Court recently noted that the framers made the president the most democratic and politically accountable official in government. The only one who, along with the vice president, is elected by the entire nation, citing case law. Quote, to justify and check the president's unique authority in our constitutional structure, Article 2 renders the president directly accountable to the people through regular elections. As James Madison put it, quote, a dependence on the people is no doubt the primary control of the government, end quote. The Federalist number 51 at 253, citing James Madison here. And then we're citing Scalia's dissent in Morrison. The founders established a single chief executive accountable to the people so that the blame could be assigned to someone who can be punished. Wow, that's powerful. Thus, the quadrennial presidential election is a crucial check on executive power because a president who adopts unpopular policies or violates the law can be voted out of office. Former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. He allegedly injected himself into a process in which the president has no role, the counting and certifying of the Electoral College votes, thereby undermining constitutionally established procedure and the will of Congress. To immunize former President Trump's actions would further aggrandize the presidential office. The presidential office, already so potent and so relatively immune from judicial review at the expense of Congress, citing Youngstown. As Justice Jackson warned, executive power has the advantage of concentration in a single head, in whose choice the whole nation has a part, making him the focus of public hopes and expectations. In drama, magnitude, and finality, his decisions so far overshadow any others that almost alone he fills the public eye and ear. No other personality in public life can begin to compete with him in access to the public mind through modern methods of communications. By his prestige as head of state and his influence upon public opinion, he exerts a leverage upon those who are supposed to check and balance his power, which often cancels their effectiveness. Okay, wonderful, VC, thank you. That's Justice Jackson's concurring opinion in the Youngstown case. We cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and have their votes count. Wow, that's very powerful. That's incredibly powerful. At bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. Oh my gosh, that's very powerful. Whoa, let's highlight that. Wow, it would be a complete collapse of our system. Good point. Oh, yikes. We don't want that. Oh my goodness. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Careful evaluation of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from federal prosecution in general, or for immunizing former President Trump from the specific charges in the indictment. In so holding, we act not in derogation of the separation of powers, but to maintain their proper balance, citing Fitzgerald. Wow, everybody. Wow. All right. And I will break at this point. I do know, or my voice will completely break, everybody. But oh my goodness, that is quite the opinion. Quite the opinion. I have a feeling that all of the judges participated in writing this. Yes, Deborah, I agree. This is an amazing opinion. Very well written. Absolutely. Absolutely. Yeah, this is incredibly well written. They slammed him. Yeah. Very eloquent. Duh. Oh my gosh. Yes, unanimous. So again, this is per curiam, which means it's from the court. So we don't know exactly who wrote it. Everyone could have written it. A couple could have written it. One could have written it. But based on the tone, I would say it was multiple people. This is amazing. And basically, they set this up so that the only thing that could overturn this, if the U.S. Supreme Court got this decision, would be to restructure our government. And that's incredible. That's incredible how they wrote it. Now, again, keep in mind, too, the D.C. Circuit is basically the highest circuit. Like, we don't really have a hierarchy of circuit courts, but keep in mind, a lot of our justices for the Supreme Court actually have come from the D.C. Circuit. So they're kind of at the top. They're top tier. They're the top level. Yeah. So, and again, with the rationale that they're using here for separation of power, I mean, that's incredible. They're saying if he is not subject to the laws that Congress writes, or indictment the executive branch executes, or the judicial branch where the judges decide, then he would be completely above our entire structure of government. Yeah. Yeah, that, I mean, it's amazing. It's incredibly well written. Incredibly. Yeah, yeah, exactly. I mean, it's been it's very well written. Yes, the Supreme Court arguments on Thursday are only about Colorado, everybody. So what I will do, it takes a couple of hours for this to process, for any of my lives to process through TikTok. It just, for some reason, that's what it takes. But as soon as it's processed, I will upload this live then to my Tube of You channel. And again, I've made it through page, let's just double check. I made it through page 40 here out of the, page 41. So I've made it to page 41. We skipped one piece, but so that's a lot. That's a lot. Appreciate you reading this. Yes, of course, of course. I will tell you though, I can feel my voice breaking, so I do need to go ahead and sign off for now, everybody. But I will post this on my Tube of You channel as soon as possible, so that we have it back up again. And I will be making a post on this as well. So thank you, everybody, for coming by. Yes, I'm so glad, I was able to come on and go for this. So it will be up on my Tube of You as soon as possible, everybody. And I do need to rest my voice for a little bit, and then I will be back again. So take care, everybody. Have a great day. And this was an amazing opinion. Highly recommend going and pulling it. Again, this is the case number up here. This is the document number. So this is the Court of Appeals decision on the immunity question. Oh my gosh, thank you for all of the gifts, everybody. I really appreciate it. All right, off I go before my voice goes. I'll catch you all later.